Hello viewers, good afternoon to all of you. I am Rashmi Ranjan Mishra, lecturer and I head of the department of Bachelor of Business Administration. So today I am going to discuss on a subject that is relating to business and corporate law. On today's discussion, I am going to discuss a new chapter that is relating to consideration. So what is meant by consideration, what is the definition of consideration as per Indian Contract Act, what are the essentials of a valid consideration, and what is no consideration, no contract, that we will discuss on today's class. So please listen carefully, attend the lecture class. If you are having any doubt, then you can give your comments in the comment section. So let us discuss what do you mean by consideration. There is one definition given by Pollock. Consideration is the price for which the promise of the other is brought, and the promise thus given for value is enforceable. So we can say that consideration means something in return, that means giving something and getting something. When somebody wants to purchase some things, in return he or she must have to give something for the value which he is going to purchase. So that something in return is called as a consideration. So the definition given by Pollock is consideration is the price for which the promise of other is brought. That means when there is certain willingness given by one party to another, or the desire of the promiser must be required at the time of a consideration, and this is for value something. That means consideration is the price, and that is made the promise of other. That means when two parties are there, they promise to make with certain agreement. In that case, the one party makes the proposal, other must accept it, and in return that must gives the price or the value for something, and that value is called as a consideration, which is given by Pollock. And the definition explains that consideration is the value for something or the price for which the promise of other is brought. According to section 2D of Indian Contract Act, there is a definition according to section 2D. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, that is past consideration, does or abstains from doing, or that is present consideration, promises to do or abstains from doing something, that is future consideration. Such act or abstinence or promise is called a consideration for the promise. So we must have to define that definition clearly. The first one is the desire of the promiser must be required. When there is no desire or willingness given by the promiser or the offerer, in that case there will be no consideration. So the first consideration or the first essential element, that means the willingness of the promiser is required to create a valid consideration, and that must move from the promisee or any other third party. So that is promisee or any other person, and there are three conditions. That may be past consideration, that may be present consideration, that may be future consideration. So the past consideration implies the word has done or abstained from doing. That means already that happened, but now we are make the payment relating to that, or we have to fulfill that transaction. Then the second one is present consideration in relation to that word does or abstains from doing. That means when consideration moves simultaneously, or the parties involving in the consideration, they must have to be make their proposal simultaneously, that is called as present consideration. And the third one is future consideration, that is the word promises to do or abstain from doing. That means something that has to be done at a later date, which is called as in future time, or that is called as a future consideration. And when that type of a situation arises, such act or abstinence or promise, that is called as a consideration for the promise. So maybe that a move from one party to another, and that is maybe an act or an abstinence or a promise, and in that case that will be called as a consideration. Whether maybe that is past consideration, maybe present consideration, maybe future consideration. So to become very clear, there is one example. P agrees to sell his car to Q. So in this case there are two parties, one is P, another one is Q. So here P agrees to sell means the desire of the P must be required to sell his car. When P does not agree to sell his car, in that case Q is not bound to purchase the car from P. So here P is the promiser because he is going to sell, that means he makes the proposal, and Q is the promisee, that means to Q the car is going to sell, or Q is ready to purchase the car, and the price consideration is rupees 50,000. P agrees to sell his car for rupees 50,000 to Q. Here Q's promise to pay 50,000 is the consideration for P's promise, and P's promise to sell the car is the consideration for Q's promise. That means when P agrees to sell his car, in that case desire of the P must be required to sell his car, and Q agrees to purchase the car, and the consideration or the value is rupees 50,000. That means P when sell his car, in return takes the 50,000 from Q, and Q when purchase the car, in return makes the payment of 50,000 to P. So that means by paying 50,000 by Q, Q must agree to take the car from P, and by making sell his car by P, then he must take 50,000 from P. So the desire of both the parties must be required, and the consideration must move simultaneously from P to Q, and the value is for rupees 50,000. This is a example for consideration. So there are certain rules or the essentials regarding a valid consideration, which is defined under section 2D. It must move at the desire of the promisor. Second, it may move from promisee or any other person. It may be an act, abstinence or forbearance, or a return for promise. Then the fourth one is it may be present, past or future. Fifth, consideration need not be adequate. It must have some values in the eyes of law. Then 6, it must be real and not illusory. 7, it must be something which the promisor is not already bound to do. 8, it must not be illegal, immoral or opposed to public policy. So these are the some of the valid rules or legal rules relating to consideration, what we can discuss in our next slide one by one. The first one is it must move at the desire of the promisor. Already we have defined in our definition as per section 2D. That means where there is a consideration, desire of the promisor must be required, or the willingness of the promisor is must be required to create a valid consideration. If there is no willingness, there is no desire of the promisor, in that case there cannot be a valid consideration. So it must be offered by the promisee at the desire or the request of the promisor. An act done at the desire or request of the third party does not form a valid consideration. That means as per the example which is given in our previous slide, when P does not agree to sell his car, in that case nobody can force to P to take the car from the hands of the P, or Q is not ready to purchase the car from P. That means the desire of P, when there is there, then P must be agree to sell his car, and in the latter case the price must be dealt. Otherwise, if there is no desire or there is no willingness of the promisor, in that case there will not be a valid consideration. And a desire at the request at the promise of the third party, that does not create a valid consideration. Then the second ground, that is it may move from the promisee or any other person. So when the promisor shows his willingness or desire, that means the promisee or any third party must give their conclusion or a result to the promisor, whether to accept that or that refuse. So consideration may move from the promisee or any other person. That means even a stranger, the consideration can also move from that stranger person. The promisee must give his acceptance or request and or approval. Even if a stranger is also there, that person can also be taken into consideration, and the consideration may also move from that stranger person. The third point is it may be an act, abstinence or forbearance or a written promise. The following are the good consideration for contract: forbearance to sue, compromise of a disputed claim, composition with a creditor. So to become very clear, we must give an example, and by going through that example we can be very clear whether that is an act or abstinence or forbearance. A borrows from B rupees 100 at 20% per annum and fails to pay the amount. When B is about to file a suit, A agrees to pay a higher rate of interest. B as a result does not file the suit. So this forbearance on the part of the B to file a suit is a sufficient consideration, and B can enforce the promise by A to pay the higher rate of interest. So in this case, A borrows from B. A borrows 100 rupees from B at a 20% rate of interest per year, but in latter case A fails to pay the amount to B what he has borrowed from B, and in that case B charged a case against A, and when B charged or file a case against A, in that case A is ready to pay a higher rate of interest and convince B not to file a case, and B also agrees with that proposal and accept that to get a higher rate of interest, and B does not file a case against the name of A, and in this case this forbearance to file a case against A is sufficient consideration, and B can enforce by A to pay the higher rate of interest, as A later on case agrees to pay higher rate of interest, so he must have to pay the rate of interest which is declared by A at a higher rate to B, and in that case B also withdraw that case what he is going to file against A. So this is an act or abstinence, either to do or not to do, or forbearance, or that is a case of a written promise. Then the fourth one is it may be past, present or future. So that is also discussed in our definition as per section 2D. Consideration may be a past consideration, may be a present consideration or future consideration. That means the word has done or abstained, that is past. The promises to do or abstains from doing, that is future, and when the simultaneously move from both the parties, that is a case of a present consideration. So past consideration, that is present or executed, the future or executory. So we can discuss it one by one by giving suitable example. Past consideration means, for example, suppose I want to make a tuition to a student. For the month of December, I already provide my coaching, and in the month of January, the student makes the tuition fees to me. So this is a case of a past consideration. That means I have already provided my service in the last month, but now I am getting my remuneration in the current month. So this is called as a past consideration. For example, in case of a present consideration, that means simultaneously move from both the parties. That means I am agreed to sell my bike for rupees 20,000 to X, and X also ready to pay rupees 20,000 to me by taking the bike from my side. So in this case, that means simultaneously move from me to X. So both are at a simultaneous situation or at present situation makes to fulfill all the consideration. So this is called as a present consideration. That means I am ready to sell my bike, and X also ready to pay rupees 20,000 to me. And in case of a future consideration, suppose I want to sell my bike to X in the month of January 2021, and X also ready to pay me same 20,000 in the month of February. So that means both will happen at a future date, and this is an example of a future consideration. That means that is a case of a executory consideration. So depending upon the situation, maybe that is a past consideration, maybe present, or maybe a future consideration. So the next one is consideration need not be adequate. That means it must have some values in the eyes of law. So consideration need not adequate, but it must have some value in the eye of law. This means something in return need not be necessarily be an equal in value to something given. So that means, one example, suppose I want to purchase one mobile and the cost of the mobile is rupees 10,000. At the time of purchasing the mobile, I said to the shopkeeper that please give him the mobile of rupees 10,000 by paying only 1,000. So this is not a sufficient consideration, because the cost of the mobile, which is 10,000, is not equal to 1,000. So that must be some values in the eyes of law. It need not be adequate. When it is not adequate, so in that case that is not called as a valid consideration. Then it must be real, not illusory. That means which must have to be or which is going to happen, so that must be possible. If that is not possible to perform, in that case that is not called as a valid consideration. So that's why it is called as a, it must be real. There is no consideration in the following case. If it is a case of a physical impossibility, that means making a dead person alive, that is not possible. We cannot make a dead person alive. So that's why the consideration must be real, that is not physically impossible. Then legal impossibility, one example is there. X file a case against Y for non-payment of debt. Y approach X brother Z, and he promises to withdraw the suit for a consideration of rupees 500, and it is legally impossible, because by giving a brief of rupees 500, case cannot be withdrawn. As per the legal procedure, that must have been taken into consideration. When it is taken into consideration of a bribe, or there is a case of any type of money providing that person, in that case that is not legally possible and that is legally impossible. When it is legally impossible, that is not called as a valid consideration. The third one is uncertain consideration. That means the consideration which is going to perform, that must have a certainty. If there is no certainty of a consideration, in that case that is not called as a valid consideration. Then the seventh point is, it must be something which the promisor is not already bound to do. That means a promise to do what one is bound to do either by general law or under an existing contract is not a good consideration. So that means when consideration is given or when it is made, that must have something that promisor is not already bound to do. That means a police officer duty is to take the case or investigate the case. In that case, at the time of investigation, if the police officer takes any type of a brief from the person, in that case that is not called as a valid consideration, because as per the rule, government providing the service to the police officer, and as per the rule of the government, the police officer duty is to provide legal justice to the general public. If in that case by investigating case police officer takes any type of a bribe, in that case that is not called as a good consideration, because his duty is to provide service, in return government provides salary or remuneration. So it must have something which the promisor is not already bound to do. The next one is, it must not be illegal, immoral, opposed to public policy. Unlawful consideration includes any activities which is forbidden by law. If any type of activities forbidden by law or prohibited by law not taken into consideration as per the legal law, in that case that is not called as a valid consideration. If any type of activity is fraudulent, that is going to cheat the other party, that is also not called as a valid consideration. Then it is of such a nature that will defeat the other person as per the provision of law, that is also not called as a valid consideration. It involves any injury to the person. Injury means not any type of injury that makes harmful activities relating to the person or against the property of another person. In that case also that is not a valid consideration. If the court regards it as immoral or opposed to public policy, in that case also the consideration or the activities is not called as a valid consideration. Then there is certain exception to the rule that no consideration, no contract, which is defined under section 25. So we already discussed that if there is no consideration, there is no contract, because consideration means something in return. Where there is giving something, there must be getting something, and that must have some values in the eyes of law. But as per section 25, there are certain exceptional cases where even if there is no consideration, still it is called as a valid contract. So the first one is, that is on account of natural love and affection, which is defined under section 25 subsection 1. The second one is for voluntary services, that is defined under section 25 subsection 2. Then the third one is for promise to pay time back debt, which is defined under section 25 subsection 3. Then the fourth one is in case of a completed gift. The fifth one is in case of agency, which is defined under section 185. Then the sixth one is remission by the promisee or performance of the promisee. So that we will discuss one by one. The first one is on account of a natural love and affection, which is defined under section 25 subsection 1. So when the consideration is made or the contract is made on account of a natural love and affection between the parties, in that case even if there is no consideration, still it is called as a valid contract. That means when an agreement is made between father and son, that to give 100 rupees for daily expenditure to the son by the father for making in and out from the room to the college. In that case, the father is not bound to take the 100 rupees values return, because his duty is to make payment to or to provide the daily expenses to his son or to his daughter. So this is as created on account of a love and affection between the father and his son or the father and his daughter. In that case, that is called as a natural love and affection. So when natural love and affection made between the parties, in that case even if there is no consideration, that is called as a valid contract. So such type of agreements are enforceable even without consideration. The second one is for voluntary services rendered, that is defined under section 25 subsection 2. A promise to compensate wholly or in part a person who has voluntarily done something for the promisor is enforceable even without consideration. So when there is a case of a voluntary service that is rendered by a person, so in that case either that is a case of whole or in part, so a person who has voluntarily done something for the promisor, that is taken into consideration and also enforceable even if there is no consideration. Suppose during taking a class in our college classroom, I am forgetting to taking my mobile and the mobile is with the students. Some of the students provide that mobile, they sir please take your mobile, you left it in our classroom, and by getting my mobile I am eagerly interested to provide 100 rupees to the student that please take it and take your lunch, because I got my mobile and the cost of the mobile is very huge amount. So as I get my mobile, so I am very happy. In relation to that, I am providing 100 rupees. So that means there is a case of a voluntary service rendered by the student to me, and I am interested by from my willingness I am going to provide that 100 rupees to student to take the lunch. So in that case there is no consideration, because the student is not interested to take 100 rupees, or he is not demanding that sir please give me 100 rupees in return for mobile. So from my side I am going to provide that 100 rupees. So that is called as a voluntary service. So when voluntary service is made, and in that case even if there is no consideration, that is taken into enforceable and that is called as a valid contract. The third one is for promise to pay a time barred debt, which is defined under section 25 of section 3. So time barred debt means time already expired. So when time expired, but even if that is taken into consideration, still it is called as a valid contract. That means a promise by a debtor to pay a time barred debt is enforceable, provided it must be in writing and also signed by the debtor or his agent. So if the time expired, that must be taken into consideration, that must be enforceable, but the condition is it must be in writing, the agreement must be in written form, and it must have also signed by the debtor or any of his authorized agent. Then in that case that is called as a valid contract, or that can be taken into enforceable. In case of a completed gift, so when gift is taken as completed gift, that means in return there is no demand, there is no value return. So in that case that is called as a completed gift. So when there is a case of a completed gift, if there is no consideration, still it is called as a valid contract. So the rule no consideration or no contract does not apply in case of a valid or a completed gift. The fifth one is in case of agency, that means which is defined under section 185. Agency implies the relationship of a principal with the agent. So to create an agency relationship, consideration is not necessary. So agency relationship is created between principal and his agent. So that means when agent is going to provide service, in return the principal is also providing salary or commission on the basis of services return or services provided. So when the services is provided by the agent, in that case the principal is also provided the fees or the remuneration or the wages. So that is the relationship, and in that case no consideration is necessary to create a valid agency relationship. The next part, that is remission by the promisee on performance of the promise, that is defined under section 63. A creditor can agree to excuse a whole debt or part of it without any consideration for doing so. A promise can agree to extend the time of a performance of a promise. So there is one example. X owes rupees 500 to Y. X pays rupees 100 and Y accept in full satisfaction of his claim. So during the initial stage, X takes provided rupees 500 to Y, but in a later case X pays rupees 100 and Y also accept in full satisfaction of his claim. So in that case, when there is a case of a remission by the promisee and there is a performance of the reciprocal promisee, in that case there is no need to make any type of a valid consideration. Even if there is no consideration, still it is called as a valid contract, and in that case the promisee can agree to extend the time of a performance of the promise. So these are the some of the part that is relating to essentials of a valid consideration, as well as the rule no consideration, no contract, and what are the exceptions. So this is our today's discussion relating to consideration, definition of a consideration, types of a consideration, and essentials and exceptions to the rule, no consideration, no contract. So hope you must have aware about that topic. Even if you have any doubt, then you can also give your comment in the comment section. Thank you. Have a nice day.